My name again is Samson Ladi Ayenini. This morning we are dealing with very vexed matters. Pensions has become a very topical issue because labor unions, about 12 of them as we speak, are on strike, and they are not, resuming or getting back to work until and unless government decides to heed their demand. Their demand, and the primary demand they are making is that government should not be the one to appoint the trustee for the second-tier occupational pension scheme. Are they right? What does the law say? We will find out how that goes. In fact, as you may know by now, government is in court seeking a proper interpretation of the law, which, when read on its face, suggests that government, who is the employer, is the one who is supposed to appoint the trustee and not the workers, as they claim. The workers have another point. We will look at all of those, and we will also be looking, subjecting the Afro Barometer Survey Round 6 to some scrutiny on the show. That survey suggests that about 57% of Ghanaians have, in the past year, not have the luxury of the basic necessities of food, water, and medical attention. That's very serious, isn't it? And that about 80% of Ghanaians think the economy is bad or very bad. About another 50 plus percent think their conditions have become worse than before. We will situate it in the period in which the survey was done and ask the critical questions. And finally, Dr. Baumia picked a third time. The NDC says a third time of another loss for the NPP in 2016. My guests are seated. Abdul Malik Kwekubaka Jr. is a regular panelist. He is the editor-in-chief of the New Crusading Guide newspaper. Charles Bawadua is a labor expert. He is a lawyer and practices with a focus on labor issues. Dr. Michael Pesa White, he is here today for one critical reason, or two. He has a PhD, and you've never bothered to find out what his PhD is about. His PhD did a work in respect of pensions. He will share some of what he knows with us. Of course, he has also followed the Afro Barometer over the years. And finally, Nana Akomia. He is a former communications director for the New Patriotic Party. Now he says he's a chief, what do you call them? Those party supporters. Foot soldier. Good morning, gentlemen, and welcome to the show.
Good morning.
Good morning. Thank you very much. Now, we want to start straight away and go into the issues that are at stake. Well, as you know, labor unions, 12 of them are on strike, and these 12 have just been sued. The Ghana Health Service Workers Union, the Ghana Registered Nurses Association, the Ghana Medical Association, the Ghana Physicians Assistants Association, the Ghana Pharmacists Association, the Ghana Association of Certified Registered Anesthetists, the Ghana National Association of Teachers and Educational Workers Union, National Association of Graduate Teachers, Coalition of Concerned Teachers, Judicial Service Staff Association of Ghana, and Civil and Local Government Staff Association of Ghana. They are all on strike. And you know, as I've already indicated, what they are demanding. The government has sued them, as it even issues a press statement calling on them to call off the strike and come back to work. Number one, I'd like to start with you, Charles. When they declared the strike, they made it very clear that they have attempted for a number of years now, almost 2 years running, to seek to get government to yield to their demands, and we'll be going to the specific demands in the course of the program, they think this is the only way out. From where you sit as a lawyer who has a lot of expertise in labor matters, is the strike legal?
Thank you, Samson. Let me first of all say good morning to your listeners and viewers. I have read very extensively the news release that was read by the group on the day of the declaration of the strike.
Right.
They have enumerated in that release the efforts they have made aimed at getting this matter resolved. They have cited meetings with the Labour Minister. They have cited meetings with the Parliamentary Select Committee on Social Welfare. They have cited meetings with other interest groups. Now, for them, they say that the strike is the last option. In my considered opinion, something, I do not believe that the strike was the last option. The reason is simple. If you look at the law governing the activities of trade unions, I'm talking particularly about the Labour Act of 2003. There are provisions regarding conflict resolutions. Indeed, strike is one of them. But by the way the law has dealt with strike actions, strike is something that ought to be used sparingly. Now, that's not what we see in this country. It would appear that in every dispute that you have with the employer, the worker wants to go on strike. Now, there were other options. For example, they could have dealt with the matter at the level of National Patriotic Committee, which is also provided for by the law. They could also have made a complaint because, for all intents and purposes, the dispute is an industrial relation dispute. It is about the welfare of the workers when they retire. So it's an industrial relation dispute. It is a matter for which they could properly have brought before the National Labour Commission for adjudication. They have failed to do that. They also have a right, as legal bodies established by law, to go to court to seek to compel government to do what they thought was right. I think that the use of a strike in this circumstance was unfortunate. As to the legality of the strike, I'm clear in my mind that the Labour Act has made extensive provisions regarding what an employee who intends to embark on strike action ought to do. From the press release, it does not appear to me that they have done that. Indeed, the notice to government, if there was any, does not survive.
Okay.
You ought also to notify.
What are they expected to do?
What they are expected
that they
to
did
do
not do, as far as you know?
First of all, the Act envisages that there should be negotiations between the parties. From their complaint, it will appear that the negotiation failed. Now, the next step they ought to have undertaken is mediation before the National Labour Commission.
So, number one, they complied with the first step.
Yes, apparently, from the content of the news release. Negotiation failed. They ought to have gone for mediation under the Labour Act before the National Labour Commission. It does not appear that they have even brought any matter before the Labour Commission. How much more for a mediation to have been conducted under the guidance of the National Labour Commission? So they failed in that respect. Now, if mediation had failed, then they ought now to have gone for arbitration. Now, the arbitration process ought to have resolved the matter. And if upon that there was no resolution, then that's where the notice to strike will come up. And you must give notice both to the Labour Commission and to the employer. This was not done. If you look at the text, the press release, they say that the strike is indefinite. Something. In this country, under the law, you cannot have a legal strike for more than 7 days at all. Because when the employee embarks on a strike action, If within 7 days of the strike action it is not resolved, National Labour Commission is supposed to call for compulsory arbitration. And whilst the compulsory arbitration process is going on, no employee is supposed to go on strike, or no employer is supposed to engage in a lockout. The opposite of a strike action is a lockout. Now, apart from that, there are aspects of it that we need to look at. That some of the groups that have been mentioned, the Ghana Medical Association, for example, are engaged in essential services. The law strictly debars people engaged in work of an essential nature from embarking on strike action. So, quite clearly, it is obvious that this action cannot be legal. Now, there are consequences for that, and it will appear that some of the reliefs that the Attorney General is seeking in court will try to resolve some of them. Because if you embark on an illegal strike, first of all, whatever damages that you would have caused to the employer in the course of the illegal strike, you are bound to pay. Apart from that,
you can't pay for the lost lives.
Exactly, of course. So herein lies the danger of the situation. Apart from that, the employer is not required to pay you. If you are not producing, what do you expect the employer to use to pay you? So in my candid opinion, I think that this matter could have been resolved by use of other mechanisms and not strike action. Clearly
we'll come to see the merits of the case that they make, particularly in respect of the appointment of a trustee for the second-tier occupational pension scheme. But you say after the negotiations, the apparent or claim negotiations failed, the second step ought to have been to petition the Labour Commission.
Yes.
Have you not heard that government rather went to the Labour Commission, or the Labour Ministry went to the Labour Commission on this matter?
Yes, so if the matter is pending before the National Labour Commission, that is where the procedures provided for under the law ought to have been pursued to the letter. There's no basis to embark on a strike action when the situation has not arisen. Especially given the fact that strike action have the propensity to affect the economy of the country. We must look beyond our immediate interests.
But you would also know, as a lawyer in jurisprudence, that the reasons why people at a certain point would decide to disobey a law. That is, I'm saying without admitting that this is what has happened, people may decide to disobey a law. They can, you know, because for example, they may know there's consequences and say we are ready to face the consequences anyway. Or they can decide to say this is just an unjust law, it's so unfair to us, and to stick to it or rather, you know, die than stick to it. In this case, these are a group of people who are saying they are not in the privileged positions of politicians and is it Article 71 office holders who enjoy ex gratia of so much amount of money. When they have done just 4 years, they get so much. They do 20, 30 years, and all they get cannot even afford any much. So this is the way to fight for what they believe is their right.
So you see, like you said, we will come to the merits or otherwise of the agitation. But this particular Labour Act that we are operating now is one of the few legislations in this country which were actually negotiated by the interested parties. In fact, it's a negotiated law. It took painstaking negotiations between government, organized labor, including the groups who are now seeking to breach its provisions, and then employer associations, to negotiate and come with the provisions of the law, including the provision relating to strike actions. So how is it that the law, which is the product, the baby of the negotiations of the parties, is now being dumped? Assuming, for example, that they are of the view that the particular provisions relating to strike is so onerous that it will be impossible to follow, or that will not be able to get immediate results. The solution lies in amendment or seeking to review the provisions of the Act, and not to breach its letter and spirit.
We'll get to that, and also you may be aware that the Labour Minister has hinted that government is minded to seek sort of a review and amendment of the law. Kweku, what do you say about the strike? It's an indefinite strike.
Well, see, we have gone this path before.
Right.
We have discussed these things, the law, the legal regime that guides strikes and the things. We've discussed all before. We've realized that there's a little challenge with its implementation. Whether it was negotiated or not, the practice over the years have shown that there's something that we need to do to the law in order to make it more realistic. It is obvious that in the present circumstances there's something wrong, because sometimes the employer, as well, and in this case government, hides under the cover of the law and protracts negotiations and allows a certain inertia, a state of inertia, to take over because the law perhaps appears to back it in its conduct. But bottom line, we are dealing with the human element. These are human beings we are dealing with. And we are dealing here with pension funds. Okay? Their retirement income security.
Right.
That's what we are dealing with. So we have to be sensitive to the human element and not just overrate the law because you think you have a chance to hide under that. That is what is happening right now. If things had been done the way they ought to be done, I'm not sure we'll be where we are with an industrial action. Okay? I'm not sure we'll be there. So all the good talk, the rationalization and the rest really do not have any effect, because something is wrong. As you said, we'll come to the basic issues, and that is where the key is. So when we proceed, I understand, you proceed by looking at the legal regime and asking whether what they are doing it's in consonance with the law or not. But when we go into details, you ask whether the conduct of the employer or government is not what has provoked an illegality, if indeed it is an illegality. You would ask that question. If people come to negotiations in good faith and are transparent and accountable relative to the principles and the laws that have been put in place, look, you would have a smooth sailing thing. This pension thing came out of a long struggle. This new law, long struggle, a commission was put in place. I've got a report here, at least. If you read it, you see the wealth of experience and knowledge that went into that place. There was a question about ownership. This is just to digress slightly. In terms when it came to the classical SNET one, ownership and responsibility. Government through the years, because of how it had handled SNET and its investments and all the rest, thought that the custodial responsibility that it had necessarily was synonymous with ownership. And because of that, thought it could dictate the pace. Professor Kumado and B.J. Darocha wrote some articles, indeed, they made inputs to the commission, and there was a divergence. Government and the state always assume that we own the project, and because we own it, they think they can handle it in any way. Whilst indeed the contributions actually are from the workers. So there was a split, there was a contradiction. That thing, even though we have now done a three-tier thing, and the SNET is dealing with the basic national security,
right, and
the second tier is the occupational thing, there's still that transfer of that conflict, ownership, and custodial responsibility.
Okay, we'll deal with it. You are dealing with it right away. Just hold on.
It's because we haven't tackled that properly.
Right.
That's why we are where we are, and then we are seeking refuge under the labor law to try and say that you are wrong. And on the surface, yes, this is an illegal thing, so you are wrong. Okay. You can't solve the problem without considering the human element.
Okay. Nana, assuming without admitting that the way in which the scheme is being handled, there's been a problem with it, is it justified, and is strike the only way to go? Strike, including strike by essential service providers who are outlawed in that regard, largely.
Well, thank you, Samson, and let me wish my co-panelists a good morning, our viewers, our listeners and viewers. I haven't followed closely the provisions of the labor law in relation to declaration of strikes. But if you look at the unions, I think there are about 12 of them or so.
Yes.
And these are unions with legal input and all of that. So I assume that they will be acting closely to the law. My colleague here, Dr. Charles, is it Charles?
Charles.
Yeah, had said that he didn't think that the labor unions have followed the law regarding declaration of strike. I don't know what the actual situation is. But for me, Samson, it is clear to me, and I'm sure to many Ghanaians, that there's political failure somewhere. Like Kweku said, you have a situation where a scheme has been established. The scheme provides that...
No, you're going into the question of the scheme itself.
No, I'm not. If you listen to me, I'm just going to the issue of the strikes. Yeah.
Okay.
I'm saying there's political failure somewhere. I'm trying to situate that political failure. I'm saying that there's a scheme that has been established. It provides that after 5 years, benefits should start accruing. People should start receiving benefits from the scheme after 5 years. Deductions started in 2010. 2010, 2011, 2012, 2013, 2014. From January 2015, people are supposed to receive. People going on retirement are supposed to start receiving the benefits. So, over the 5 years, there hasn't been a conclusion as to the management of the funds, which will then make possible the disbursement of the funds to those who are eligible. So if we have sat down, and Dr. Charles was enumerating some of the, all this engagement over the management started 2-3 years ago. Now we've sat down, we have waited for all the 5 years.
Charles Bawadua, I don't know, has a PhD yet.
No, not yet.
Or maybe he's been fortunate to have one of these institutions also bestow on him a doctorate. So he's Mr. Charles Bawadua.
Okay. You mentioned a doctorate somewhere, so I thought it was
Dr. Professor White.
Okay. All right, Mr. Charles. So, but it's a promotion, so take it. Now, there has been engagement between the workers, the labor unions, and government.
Right.
5 years, there has been no conclusion. In a few months, 2-3 months, January, people are supposed to receive monies. So there has been political failure somewhere along the line that has brought us to this place where they announce strike actions and counter-court actions and so on. Why is it that in 5 years, when deductions started in 2010, and we've continued with the deductions, and yet the payments are due, and we haven't managed to put in place an acceptable management of the funds that will make possible payments to people, and the payments are due. That's where I believe that there's political failure.
And that's why the strike is justified, as far as you're concerned?
Well, I told you initially that I haven't checked if the workers had scrupulously followed the provisions of the Labour Act in declaration of strike. But I'm saying that whatever is happening today, it has been occasioned by
so as far as you are concerned,
failure.
If they have not followed the procedure, it's not justified. But if they have followed it, it's justified.
If they haven't followed the procedure, then they have to be blamed for not following the procedure. I mean, the government should take them on. All of us should take them on and ask them the simple question that, so you've been negotiating for 2-3 years. You want to declare a strike. Why haven't you followed a simple procedure? So they too have to be taken to task if that is the case.
Okay. Dr. White, briefly about the strike and how you see it.
Well, I will proceed from, good morning to our cherished listeners. I'll proceed from where Nana Kumia left off, particularly with respect to negotiating for a number of years, and at some point in time, especially around this point in time, Labour decided to go on strike. Earlier on, my senior colleague here, Kweku Bakon, mentioned that government has been hiding behind the law to protract negotiations. I think we need to be very careful. There are two parties to a situation of this kind. And unless the facts are very clear, generalized conclusions can be very fallacious, in the sense that I have been to some of these negotiations with Labour. I have sat in some of these meetings, and it is not clear to me that of the two parties that normally meet at the table, it is government at all points in time that is demonstrating bad faith or is protracting. What do you do when government continues to concede and say, okay, we have seen this one, we will work with it, we will review the situation, we will accommodate this, and Labour continues to say, if you don't take exactly what we bring to the table, we will not yield a single mile or a single inch of the process. So we need to be careful, and I think we need to be extremely fair. Strikes generally are not good for our economy. And it doesn't matter which political party is in power. Nana Kumia has been in government before, and they have also been in situations where they have to negotiate with Labour before. And I am not too sure whether, I believe he probably, because I believe he was in charge of Labour at some point. If we have to be fair, more often than not, and this is part of the problem in this country, more often than not, Labour unions elected to lead the unions come to the negotiations without any expertise in the issues that are supposed to be discussed. They are elected presidents and secretaries and so on and so forth. What other Labour unions do across the world is that they hire experts in the specific issue areas to negotiate or to lead the negotiations on their behalf. But when you put the experts together, they are much more likely to resolve the issue amicably, guided by the interests of both Labour and government. As it is now, if you scan through the leadership of the unions on the matters that are arising as far as pensions is concerned, none of them, as far as my reading is concerned, has an expertise in this. So you have to ask yourself, do we really have the right caliber of people by way of expertise negotiating on behalf of Labour? My point of view is that...
But you would have expected that sometimes they will come to the table with the benefit of some consultation that they've had. They would have engaged some consultants to do some work for them.
I haven't
and
seen
in this
that
particular
yet.
case, I think they have done that.
I haven't seen that yet, at least in the negotiations I have seen. And I have seen quite a number of Labour experts that have consulted for Labour, who clearly say, look, what Labour is asking for in this particular case is completely wrong, both in law and in policy, and of course also in policy history. Now, the question about we have protracted this and then there is a 5-year within which we have to talk in terms of what is the specific design of the second tier. If we know the design of the second tier, this question about within 5 years people will go on retirement and there will not arise at all. The second tier is what we call a defined contribution pension scheme. What does that mean? It means that every worker in this particular case...
Your views on the strike should not go into the discussion of the subject itself, because we are going to do that right after this.
Okay, all right, that's fine.
Right. Okay, so we'll just take those as your preliminary views on the strike itself. You're here on Newsfile on Joy 99.7 FM radio, and I'm aware that some of you are getting ready and you are getting to the old schools reunion. Well, just get ready. We'll finish here and join you there as well. Your views and comments are welcome. 1422, that's a text line. And you could also post them on our Facebook wall or send them to newsfile@myjoyonline.com. Let us listen to Haruna Idrisu, who is the Minister in charge of Labour Relations, what he had to say yesterday in seeking to appeal to Labour to stop the strike and return to negotiations.
It is a potential future risk that both government and unions and workers cannot anticipate today. You won't know whether the managed will be managed well or not. But at least you can trust government. Government is government. It probably may not be my government today, but a future government, but it's government. So the question I'd like to pose to Ghanaian workers and Ghanaian citizens, is it not better to entrust your future in the hands of government than a union worker or a union leader who himself may be due for retirement possibly? We've heard concerns that where is the money? We want our money. The money is with the Bank of Ghana. The governor is a custodian of all monies, including that money. And I'm happy to note that is been invested in treasury bills and has yielded some returns, indeed very good returns.
Right, that's the Minister in charge of Labor Relations. Let's listen briefly to one of the concerned unions that are presently on an indefinite strike. And I'm talking about the Coalition of Concerned Teachers. Let's hear their leader, Ernest Opoku.
We have indicated that if government still want to bring some people, government appointees on the board, they can remove GES officials and bring their own officials to come and serve on the board. The disagreement is that government don't want public sector workers to establish their second tier, but rather government want to box all public sector workers under one fund manager, and that is the disagreement.
All right, so we want to move away from the strike. The unions are on strike, and they are saying that they have even met the president. 2012, they have held several meetings and have had some assurances. It appears that in the end, government doesn't seem committed to their point of view as far as the matter is concerned. Now, let's answer the question. Who is doing wrong in the issue? Is it the government or it's the labor unions that are wrong on this matter? I'd like to start on this note with Charles again. Now, Charles, tell us what you know as far as the law is concerned on how this process is supposed to operate. There's a bit of a summary I've tried to do. Let me just share that with you as far as the law is concerned. The law, that is Part 3 of the National Pensions Act 2008, Act 766. When you read from Section 96 going, it requires the employer to deduct 5% of the salary of the employee. This contribution of 5% out of a total, out of a total of 18.5% made on behalf of the worker, the law says, shall be held, and I'm quoting, shall be held by the employer in trust until remitted to the trustee of the occupational pension scheme. I quote closed. The remittance is to be effected, and the law also says shall, which makes it mandatory, is to be effected within 14 days from the end of each month. That's the law I'm quoting. Now, Section 218, that's 218, also is to the effect that from the commencement of the law and before the licensing or registration of trustees, pension fund managers and custodians, every employer shall open a temporary occupational pension fund account with the Bank of Ghana. The funds so deducted shall be lodged in this account pending the licensing of trustees, fund managers and custodians. Then the NPRA board shall, again the law uses shall, within 90 days of licensing or registration of the trustees, pension fund managers or custodians, compute and transfer all contributions and returns to the credit of the occupational pension fund account opened with the chosen trustees licensed by the board. Then finally, Section 219 requires each employee to be issued with a Ghana government retirement bond equivalent to the benefit due the worker as computed. What is the problem now is that government has appointed the trustee. The workers say, hell no.
You see, if you look at the issue at hand, it seems to me that there's a single issue. Who appoints the trustees? That is the issue. Now, there is no doubt that when the deductions are made, 5% from the 18.5% that would have been originally deducted from the salaries of the workers and that of the employer. Now, when the money is deducted within 14 days, between the period of the day of deduction and 14 days, no doubt, the law is very clear, that the employer is holding on to the money in trust for the employee. Now, what happens after the 14 days? The employer is required to now have this money transferred to the trustees, farm managers. Now, the question now is, who chooses these trustees, these farm managers? That is the bottleneck. The ownership of the money is not in doubt. If you look at section 98(1) of the Act, it talks about vesting. It says that's the first part of it, subsection 1. A contribution in respect of a member of a scheme vests in the member as accrued benefits as soon as it is paid to the approved trustees of the scheme. So ownership of the money is not in doubt at all. So it's left the little issue of who chooses the manager. For me, there is a kind of a lacuna in the law that has not been specifically spelled out. Yes. If you look at section 4, you are dealing with management of the schemes, and section 4 deals with all the schemes in particular. Now it says that the basic national social security scheme shall operate under the trust established under section 52 of this Act. So when it comes to the basic national social security scheme, nobody is in doubt.
Senate.
Yes, Senate. Senate is the one operating.
Right.
Now you go to subsection 2. It says that the occupational pension scheme, provident fund schemes, that is the third tier, personal pension scheme and other privately managed pension schemes shall be managed by trustees approved by the board. Now, the part, that is the Pension Alliance Trust, which government is trying to push for the management of the scheme, has been approved by the board. The other schemes that the occupational groups have put in place, the unions have also been approved by the board. So all those authorities, all those companies have the capacity, legal capacity, I mean, to manage because they have been approved by the board. But the question is, to who of them? What does government say, I prefer part? The workers say, no, we want our own schemes. I think it's this which is before the court for adjudication. And my view is that there is no clear provision, save for the fact that the money is for the workers, as to who does the appointment. Maybe we need to look at it for a clearer future.
I see. Abdul Malik, if you can assist us, what do you know to be the history for this new engineering about the scheme? Because it didn't exist. It took some agitation, some consultation, then we decided that we need a second tier to provide for what purposes?
Well, if you go back to the colonial days, there was this Cap 30, which chapter 30 of the colonial ordinance, you know, that was 42, ordinance 42. It was strictly, it wasn't funded. It's charged on the state coffers. It carried on to recent years. Most of the workers initially preferred that, you know, you get a lump sum upon retirement, but that was charged on a consolidated fund. It was a bit tricky, you know, in terms of its sustainability, whether that could be sustained or not. So a lot of things came up. People started agitating, new ideas came up, and I think it was somewhere in 2004 that President Kufuor appointed a commission, set up a commission headed by T.A. Bediako, quite an experienced person. They went through it. I have at least the interim report here, and it gives us a lot of details as to how things went. A memorandum was received from various civil society groups, organized labor, and other industrial relations experts. And they came up with the idea of having a three-tier system. SNET initially was in charge of this whole thing, but then they divided it into three. What you call the basic national security scheme, the occupation pension scheme, and then there's a voluntary one, which is Provident Fund and other things. If you read this report carefully, of course, eventually Parliament had to come in and pass this law, which is the National Pensions Act 2008. I think the focus right now is on the second tier.
Right.
I haven't had much disagreement relative to the first.
There's been none.
Or the third.
I'm not aware of it.
So it is the second tier. You see, I suspect, and this is just might be speculative, the workers, the unions, based on previous history of how the SNET pension scheme was handled, the mismanagement, misapplications, and the misinvestments, if I may say so, that occurred. And if you read this T.A. Bediako report, they give an account of how some forensic audits over a 10-year period of how the SNET pension scheme had been handled, and the confusion and the challenges that arose. So workers developed a certain mistrust. In spite of the fact that we had worker representation on the SNET board, it appears that when it came to transparency and accountability relative to how their pensions funds had been invested, it was difficult to come to any credible resource. So this whole debate, argument over second tier as to who owns, in the law, yes, it's clear. But you see, government has an implicit custodial responsibility relative to this matter. I think there's a conflict. It ought not to have been if there was good faith in terms of negotiations. See, if a board, this national regulatory body, NPRA, National Pensions Act was 2007, 12 December. A board, a 10-member board of the NPRA was inaugurated on 31st August 2009. President Mills launched this whole pension scheme 16th September 2009. Implementation date was 1st January 2010. See, question. What have we been doing since 2010, 29, 16th September? We knew that implementation will begin 2010, 1st January. We are talking here the second year.
Right.
And we knew the things to be done. Now we are told, and it's true, that various trustees have been approved by the board. Why are we where we are today? Asking questions as to which trustee should manage the second tier. Apparently, government has its preference. But couldn't that have been dealt with in a very negotiated manner? Couldn't we have sought the consent or a certain consensus from labor relative to, is it a PTA? Who are they? What are they? There appears to be even people who have problems in spite of the board approval of the Pensions Alliance Trust. Am I right?
Yes.
People have problems with them. People wonder who they are, what they are, what's their track record, what are the connections some of them might have with government. There's a suspicion out there. I'm telling you, that's the bloody truth. A lot of people have also, I'm not saying I have, but I'm saying it's out there. And that is why would I
they have fulfilled all the requirements and complied, and because of that they have been sole registered.
How about the
licensed?
The workers have their preferences.
Right.
Have they also fulfilled requirements?
Certainly, that's why they've been approved.
And that is why indeed it would have required that the employer and the employees relative to this particular second tier, because of the history that we've had. And that's why I kept on making the point about the human element. That you see, when you always proceed on basis of strict law or strict documentations and things, without looking at the human element, you will lose a negotiating process. That's my own feeling. So this matter, I believe, we ought to bring the parties back onto the negotiating table. There clearly can be a compromise as to who should be in charge of second tier. Other issues that have been raised about, okay, by January 2015, accrued benefits may have to come in, some retirees may have to get their things. Those things, I think, are challenges that can be easily handled.
They are not even challenges at all if we understand the...
Okay, you are an expert there, I'm not an expert there. But you see, these are things that are being articulated out there by sections of labor and civil society. So if they are properly handled, I'm sure we'll terminate this strike, except that government appears to be looking for a certain final solution, quote unquote, so has proceeded to court. I see that as a point of escalation. I am not too sure if that can build mutual confidence. I'm not too sure if that path can build trust, even after the court has ruled. I'm not too sure. I think that when it comes to this kind of things, the human element is so critical that we ought to move away from confrontation, come to the table and get a solution done. I'm not an expert, but the little I've read tells me we are not on the right path.
Okay. It may be important. It may be important, Dr. Kusawai, to stay on the plank of the disagreement, which is who appoints the trustee. Now, one of those who consulted for the Presidential Commission wrote this, and this seeks to, he sought to explain Section 129. I think Charles would open there and wait so that you can let us know whether where you said there's a problem with who should appoint and that there's a lacuna or there's a gap. Reading that and let us know whether you still believe that there is a gap. Now, that part of the provision is to the effect, that is Section 129, says, an application for the registration of an occupational pension or provident fund scheme as an employer-sponsored scheme may be made to the board only by a company which has been approved as a trustee or has applied for approval. Two or more individuals who are approved trustees or who have applied for approval, and at least one is an independent trustee. And the final one, a company and one or more individuals. Now, when you go to read the interpretation part of the law, it defines what an employer in this context means and what an employer-sponsored scheme means. An employer, he says, A, means the owner of an establishment or the person who, or the board which has the ultimate control over the affairs of the establishment, blah, blah. Then employer-sponsored scheme, he says, means a single employer scheme whose membership is limited to the employees of the sponsoring company and only its associated companies. Now, the one who wrote to the Presidential Commission explains this part, just a short portion. He says, workers' participation in the new scheme. There are two options available to former workers to participate in the new pension scheme. Option one is to participate in an employer-sponsored scheme, which is a single employer scheme whose membership is limited to the employees of a particular organization. He says, employer-sponsored does not mean the employer should solely establish the scheme. Sponsorship in this sense would not imply ownership. The rightful approach would be for the employer and workers to agree to set it up.
Well, I think that is an opinion of an individual like anybody else. And I will leave, especially now that the issue is in court, I will leave the interpretation to the court. But what I think is important is the question about who owns the scheme and all this confusion can never be understood if we don't disentangle what the design of the second tier is. Because it appears to me that all the confusion revolves around the second tier. What is the second tier? As I indicated in my earlier submission, it is what we call a defined contribution scheme. Defined contribution scheme is very simple. What it means is that for an employer who is contributing towards this scheme, your benefit at the end of retirement is the total contribution you have made from the time you began to the day you retire. The total contribution, all the monthly contributions put together, plus whatever interest may have accrued on that, minus whatever administrative charges may have been charged or may have been levied by those who were managing the scheme for you. So really, there is no difficulty at all about those who may be retiring in January. They knew when they started, they knew how much they were contributing, and they knew how much they would have contributed by the 1st of January 2015 when they would have been retiring. Interest rates, if it's invested in treasury bill, as the labor minister made us understand yesterday, interest rates will be properly calculated and put on it, and they will have their money. There will be no problem whatsoever. So I think that fear needs to be completely, that needs to be allayed properly. Secondly, we need to also correct the impression that this was solely a contribution from employees. The total pensions contribution in this country is 18%. 13% is contributed by the employer. 5.5% by the employee. So there is a reason why the employer needs to be mindful and careful about how the funds that have so been contributed, which when a person retires, that money reverts to the person, are invested and used. You see, we need to be careful about a couple of things. Government, as far as issues of labor and pension are concerned, plays a dual role. Government as an employer and government as an instrument of state authority. As an employer, government doubles in things like negotiating wages, labor relations, and so on and so forth, making sure that we have peaceful industrial harmony, we manage our tripartite issues very well, labor and government have good relations, and so on and so forth. But government as an instrument of state has a responsibility to ensure that every citizen is properly protected and every citizen is given an opportunity not to fall into poverty or not to be unduly exploited as far as, especially in this case, the funds contributed so are concerned. When Kweku gave the historical narrative, a few things that were missing. Yes, we had captivity from the colonial era. In the 1960s, what Dr. Kwame Nkrumah did, particularly in 1960, was to establish what was called a Provident Fund. The Provident Fund was basically almost the same as the current second tier. Your total contributions plus interest when you retire given to you, and then you go home and settle and use your money for whatever you want. But in the 1970s, when the global oil crisis hit us and our commodity prices went down, and investments in this Provident Fund basically collapsed, individuals who were members of these workers who belonged to these Provident Funds were the losers. How? Because of depreciation, inflation, and so on and so forth, the monies they so contributed into investments in the Provident Fund became nothing. In fact, there were instances where people picked their entire retirement savings in the Provident Fund, and all they could buy was a loaf of bread or kinky. What happened? Governments, as an instrument of state authority, had to step in at this point to protect its citizens who are falling into poverty, especially its citizens who have devoted their lives to managing the affairs of the state as public servants. And this is not a question of whether government is formed by NDC or MPP. It's government in perpetuity. Secondly, it is imperative to keep in mind that so long as it is government that made the law that mandates Ghanaian workers to make 5% of their contribution into the second tier, whether that money is invested by a private sector operative or a public sector operative, if that fund goes bust, government as the one who compelled that citizen to put 5% of his funds into that second tier is impliedly responsible to ensure that that citizen do not unduly suffer. So it appears to me that the position between government and labor now is, labor is saying, give us our money and we'll manage it ourselves. And government is saying, we are concerned about the welfare of Ghanaian workers when they retire, when they no longer belong to unions, when they are individual pensioners and retirees. And government is saying the labor market is highly unpredictable. Market is great. We can invest in the market, but the market is highly unpredictable. Investments can go bust any day. And when they do, the ultimate fall will come back to government. So what government is saying is simply that, look, for the long-term interest of workers, for the risks that we cannot see today, we are hesitant to basically throw all the contributions to labor. I recall somebody saying, what about government asking labor to sign undertaking that if the funds go bust, government has nothing to do? Well, you have to keep in mind that that undertaking can never work. Why it cannot work is that at the time that, God forbid, the fund goes bust, those individuals are citizens, and you cannot look back and say, because you have signed this particular undertaking, as a government, we will not, move in. But we need to look at a few examples. By the time we were adopting this second tier, several countries have traveled that path. The question is, how much do we learn from their experience? This defined contribution scheme, the first country to pilot it in recent memory was Chile. And what they did was basically to go full ballistic defined contribution. So there was nothing like first tier, second tier, third tier, everything just based on what we call the second tier right now. And it was highly praised by the World Bank as a model of pension scheme. Why? Because the social security or the social insurance scheme like SNIT was before was beginning to put a lot of pressure on government budgets and government finances, similar to the capitated pressure as well. So everybody thought if you can individualize the schemes and people can take the risk for themselves and then invest their funds where they want, that is fine. When Chile did it, there were over 23 fund managers who rose up and started investing funds. As we speak today, many Chileans had regretted, and many of those funds had collapsed. From 28 funds, now they have just about 3 funds. Government had regulated it in a manner that, at the end of the day, government doesn't have to take the fall. The point is that...
So if the law allows them to take their own risk, why do you want to assume the risk for them?
No. You see, the point is this. There is an implicit assumption that in defined contribution schemes, the individual assumes the risk. But then the question you have to ask yourself is, in a larger political system, does it make sense for a government at any point in time to transfer a risk as dangerous as this that undermines retirement income security to individual workers, especially when they are old and they no longer belong to unions?
The question to ask on that also will be this, that why did we in the first place conceive and give birth to this particular second tier?
So that is what I was
the purpose?
Well,
and what does the law say?
Well, there are a number of reasons that have been thrown around for why we did what we did. One was because SNIT was perceived to have been mismanaged. I think we have seen it in the news in previous years. But I think for many countries that have done this, the larger reason why they did that was to diversify the sources of retirement income. To make sure that when you retire, part of your income is coming from another source, another is coming from another source. And in fact, to be honest with you, SNIT, as it was before, was performing that function. It gives you a lump sum and subsequently gives you monthly benefits. In the wisdom of those who framed the law and those who carried out the reforms, they said, let's take out the lump sum aspect and allow it to float in the private market and so on and so forth, which is what it is right now. But the fundamental question that we always need to keep in mind is the UK experience, the Maxwell experience. Maxwell was a man who invested a lot of pension funds in the UK. Many of those pension funds, unknowing to a lot of people, had gone bust. One day he took his yacht and went to the high sea and never returned. All those people who invested their funds lost.
Right.
Government had to then rise up
build them out.
and build them out.
Okay.
This is the crux of the matter. For a minute, so government's position is an inherent position to ensure that Ghanaian workers do not, at the end of the day, especially when they retire, do not fall victim to a fund that has gone bust.
Okay.
And I believe that government, be it NDC or MPP, should take this position or will take this position in order to protect Ghanaian workers.
Thank you very much. Now, Nana, like Dr. Pesa says, that, look, government wants to protect the ultimate interest of pensioners. And this is the reason government feels it has a vested interest. Number one, government is the employer anyway. So the employees say, yes, we know that you want to protect us, but leave us to take our own decision. Let us take our own risk. Let us make our own mistakes. Let a Maxwell come up within our time and decide to squander our money. That will be our business. Why should government not yield to this?
Samson, just one or two quick reactions to something that Dr. Professor White said. You know, this business about labor unions not having the expertise, I think it's an unfortunate statement. I don't know if that is what you imply, but you need to clarify it, because the implication is that the labor unions, and together with their leaders, do not seem to have expertise pursuing the interests of labor. And if you are not careful, you can't be misconstrued.
Well, before you go on, if you permit me respectfully to clarify, I specifically said if you scan through the current leadership of the labor unions, it doesn't appear to me that, in particular with respect to these pensions, I do not see any one of them that has the expertise in the area to forcefully negotiate this on behalf of the unions. And that what they needed was to probably go for experts who will give them a much better and deeper understanding of the terrain to serve the interests of labor better.
I find that that statement a bit problematic. I have dealt with labor unions because I was working at the Ministry of Manpower, and I found the leaders very knowledgeable at the level of, say, CLOSAC, the civil servants, the leaders that they choose. And these people go to programs to enrich their knowledge all the time at the level of the TUC.
That may be during your time.
I cannot believe that the quality of leadership of labor has deteriorated in the last 6 years.
You know what? Take your turn and move on rather than reacting, and then we will have a reaction or from reaction.
I thought that's the statement that a particular group of Ghanaians do not have the skill to pursue their own interests. I find that a little problematic.
I think you are trying to score a cheap political point from a harmless comment, and that is completely needless. What is important is to focus on the issue as taken.
Well,
thank you. Thank you.
If you think some people don't have the expertise for their own interests, well, that's up to you.
And he's saying that you are misinterpreting him and focusing for a certain political purpose.
He repeated it. Well, but anyway, I mean, let's leave it to the people concerned. Now, the 5-year thing, Samson, as we speak, payments are due from January. The vehicle are identified by the law for those payments. The vehicles are not in place. So now who is going to make the payments? The Bank of Ghana? That is not what the law envisaged. That's why I said that there has been serious political failure over the last 5 years.
The law says there should be a temporary account with the Bank of Ghana.
There is a transitional provision in the law.
Please allow me. That account exists, and the monies have been lodged into this account. That's what we are told.
And the payments?
Total contributions plus interest.
The payments by who? The Bank of Ghana?
From within the temporary account.
Because that is not what the law envisages. If you go to the portion of payments, the payment should be made by the trustees. But because of the political failure, and Kuku Baku also took his time to enumerate it. Anyway. Okay. But you see, the core issue, Samson, is who should manage the funds. And that's the core issue. And that's why the government has gone to court. Well, if the matter is in court, I don't think we can make definitive pronouncements on it. But I will just situate my thoughts on it, on what the law provides. If you look at the law, the Act 766, schedule, the Section 1, says there's established by this Act a 3-tier pension scheme. The first one is the SNIT, which is mandatory. The second one, it says a mandatory, fully funded, privately managed occupation pension scheme. Okay, fully funded, privately managed occupation pension scheme. Then when you go to Section 3, about the contributions, how to fund the 3-tier, it says that the first tier will be funded basically by the employer, paying 13% of the salary of the employee. Correct. So let's say government will pay 13% of the salary. When you go to the second tier, whose management we are talking about, it says that the deduction will be made directly from the worker's salary. See, an employer of an establishment shall pay for each month in respect of each worker an employer's contribution of amount, no, this is for the first year. Now, out of the total contribution of 18, blah, 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 blah. Yes, the 5% is not coming from government. It's coming from a deduction from the worker's salary. Okay. Then when you go to the trust, it provides that the trust shall regulate and monitor the operation of the scheme. So in my view, the government is represented in the regulation and monitoring of the whole scheme. That's where the public, because the regulatory authority, which is the National Pension, is a public body. So government has a vehicle to ensure that the activities of the trustees are managed properly for the benefit and welfare of workers. But when you go to the management of the schemes, Section 4 of the law says that the basic one, the SNIT one, shall operate under the trust, that's the SNIT, and established under Section 32. Then the Tier 2 and the Tier 3, it provides that the occupational pension schemes, provident pension, blah, 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 and other private management schemes shall be managed by trustees approved by the board. The board, in this sense, the National Pensions Authority Board. So the law itself envisages a number of trustees, and it also envisages choice by the labor unions. You have a situation now where it is the government which is choosing a private company, because the company that is chosen by the government is supposed to be a private company. Why is the government choosing a private company to manage workers' funds? And the same provision of the law envisages that many private companies would be approved to manage the scheme. I mean, why does the law provide for many trustees to apply? I think up to date there must have been 20 companies, 20 trustees approved to manage the schemes. So it envisages that the workers have choice. Now you have a situation where the government is saying, no, you have no choice. I am going to choose one private company for you. No. So that's my reading of the law. This is what I get. Because it talks about that the money should be privately managed. There it is. It didn't talk about public management. SNIT is a public institution. Mm-hmm. For the second tier, the law envisages private management.
That's correct.
So why is the government of Ghana choosing a private company to manage workers' funds?
The government response to you is that the appointment of Pension Alliance Trust to administer and manage the second-tier pension of public sector workers was done after a rigorous screening by the Minister of Finance of 5 short-listed companies in accordance with the criteria set up by the National Pension Regulatory Authority.
So in that case,
without consulting the organized labor.
Yes, without the agreement, not even without the agreement of the people whose monies are going to be managed. That's number one. Number two, is the government saying that there's only one company out of the 20 or more companies that is qualified to manage the funds?
That there were 5 shortlisted. Yes. And out of the 5...
Shortlisted by with the government?
Samson, I think we are actually confusing a number of things.
Okay, show us.
Trustees. There are trustees. There are fund managers.
Quote the law.
Hold on. In the law, I will not quote. Sure. You hold the law. In the law, there are trustees. There are fund managers.
And there are custodians.
That's correct.
Okay. What is happening here is this. It may well be right that the law contemplates multiple trustees. Okay. The problem here is that we are talking as if the only category of workers in this country are public sector workers. There could be multiple trustees. That is true. But private sector workers could also choose their trustees from those multiple trustees. Government, as an employer of public sector workers, could also choose its trustees from those multiple trustees.
Thank you. You can end there. Thank you.
So what
Move
is
on.
The private workers, the private entities, what should their management choose for them the trustees?
Do you know what is happening there? That is exactly what is happening there.
Okay.
The employers in the private sector have taken the lead.
Okay, Nana, so if you keep asking questions, you have to get answers from...
I'm just reading.
Okay.
You see, I don't want to make a definitive pronouncement because I said the matter is in court, but I'm just reading the
This is a public
aspects.
interest matter. Let's not be too cagey about
okay,
being
fine, no
in
problem.
court.
In my view, the government should allow the labor unions to choose their own managers. And the government should stick to regulation to make sure that workers' funds will not be mismanaged, so that the Maxwell doesn't occur. I mean, it's like the government has, there are public banks.
Yeah, so his explanation to you now is this. It is the employer who is supposed to sponsor the trustee. In respect of the public sector workers, who is their employer? Government. In respect of the other...
No, in the law, it doesn't say that the employer should sponsor the...
In section 219.
Where is it?
129.
129, okay.
Yes. If you find 129, and then if you go to 211, it will explain the employer and the employer sponsor. That is where I say that one of the consultants say that the law in the way it is couched doesn't mean that it is only the government or the employer who should pick the person, but that should be done in consultation, like Okubako is saying, and you have suggested earlier, together with the employees.
Absolutely. And the employee, because this is a direct deduction from the employee's own, it's not like the first year, where this is the government contributing 13% of your salary. With the second tier, it is a direct deduction of 5% from the worker's own salary.
Again, that is not correct. I think we need to. It is not correct.
Why?
Okay, you see, please note.
Because no, but you don't quote the law, and then you are telling us that this is your view. Well, I'm holding the law here, and it's saying where the deduction should be made.
I think that we are talking to Ghanaians generally through this channel and holding the piece of book and say, quote the law, quote the law. What is the state of pension contributions in this country? 18.5% in total.
You noted, let me finish.
Okay.
Look,
thank you.
Samson, I'm holding the law. Section 3 talks about contributions to the scheme. Section 3.1 says an employer of an establishment shall deduct from the salary of every worker an amount equal to 5.5%. Okay?
Right.
Section 3.2 says the employer should contribute an amount of 13%. So when it comes to the contributions, as far as the law is concerned, I'm not giving my personal view here. I'm quoting the law. Section 3.1 states clearly that the 5.5% should be deducted from the salary, and the 13% will be contributed by the government. The 13% will be managed by SNIT. The 5%, which is coming from the worker's own salary, the worker is saying that, give me the chance to choose. That's what goes to the second tier. That's what goes to the second tier. So those are the contributions of the. And I'm saying that it's like, if you stretch this argument that the government should choose because it wants to protect workers, it's like, then the government could say that it will choose the banks that we should save. Because there are public banks and there are private banks, okay? But there's a regulatory authority to make sure that whichever bank that you take your monies to, that there will not be dealings that will lead to the saver, to the Ghanaian being shortchanged.
You will not have a pyramid experience.
Exactly. Even then, there are pyramid experiences. Even with the government regulating the Bank of Ghana and all of the laws, there are still pyramid experiences. So government should concentrate on the regulatory function
Charles,
and let the workers choose their own management.
His explanation of Section 3,
yes.
Is this something that you understand is the correct position?
No, unfortunately. You see, what Section 3 provides for is the general provisions relating to the scheme, both the basic pension scheme and then the occupational pension scheme together combined. So, holistically, 13% will be deducted, 13% of the worker's salary will be taken from the employer. The employer will now take 5.5% from the worker's salary. That brings it to 18.5%, all together for the worker. Now, the law now says, pursuant, I think what
Nana is saying,
yes,
the 5%.
No, I'm going to, sorry,
just read the law.
Yes,
Nana is saying, the 5%
yes,
is the individual worker's own contribution, direct.
That's
deducted by the
But the 13% is the employer's contribution to the individual.
That is not correct. You see, if you look at section, please look at section 96. I'm referring to the law, please.
Which section?
If you look at section 96, it defines the 5% that is going to the occupational pension scheme. And it's very clear. Then it says that, 96.1, subject to section 3.1 and 2, an employer of an establishment shall remit a mandatory contribution of 5% to the approved trustees of occupational pension schemes out of the total contribution of 18.5%. So basically, as a whole, the employer will contribute 13%. The worker contributes 5.5%.
So you are saying the same thing. If you remove the legalese, that's what it
No,
takes.
what we say, there is no direct link between the workers' contribution.
Why is the law making the employee to directly benefit from accruals upon the 5% which is given to the trustee?
In fact, going by another argument, it would have meant that then the employer's contribution to the occupational pensions should have been 5.5%. Yeah. Because it is 5.5% which is deducted from the employee's salary. The employee's
going by the same
salary.
contribution, it means the employee does not make any contribution into the first year.
At all. So when it comes together, it's a whole box for the benefit of the employee.
Okay.
Now from that box, you make 5%. You no longer distinguish who has contributed what.
Okay. Thank you very much. Now, Dr. Fusa, you were trying to make a distinction between trustee, fund managers, and custodian, custodians. So what's the distinction, and how does that change the present debate?
I think that in my view, and based on Nana Kumia's explanation, is also probably where there is a lot of misinformation. The trustees do not manage the funds. Let's get that clear. The trustees exercise policy directive of the funds. Following that, the trustees choose a number of fund managers.
Correct.
Multiple number of fund managers. And flowing from that, a number of custodians as well. So what we need to keep in mind here is that there is nothing like government has chosen one trustee to manage the funds. Government has probably chosen, a trustee to provide policy direction as far as the management of public sector workers' funds are concerned. And
the government is saying, I have the right as the employer.
That's correct.
To choose the trustee for my employees.
That's correct.
Who are public sector workers.
That's correct.
So that's what is happening. And these public sector workers, by their understanding, government should not be doing that.
Why should they think government shouldn't be doing that? Because as I explained earlier on, you see, part of this confusion is this. There are two perspectives from which this confusion is arising. Labor is seeing the contributions as money to be invested. And so they have an interest in making sure they take the money and invest it.
But it is correct that is money to be invested.
Hold on. The fundamental principle of any pensions contribution is to secure the retirement income security of the worker.
Invest it so that I can have sufficient when I retire.
That is correct. That is correct. That is the fundamental thing. So the point then becomes, how do we, from the premises of the retirement income security of the worker, how then do we move forward in ensuring that when the worker attains the retirement age, he gets a good enough benefit from his or her contributions? I think that we need to be extremely careful because the risk involved is not for today. The risk involved is for several years down the line. And what it also meant is that when you retire and you no longer belong to teachers' union or whatever union, it is you, the individual Ghanaian, against the company that has invested your contribution. You will be lost in the 25 million Ghanaians.
He says, leave me alone, let me be lost.
But at this point, I don't think that the individual worker understands that that is what is being argued on his behalf by the unions.
Right.
Because
very
that,
interesting.
in my view, is where the problem is.
Now, Kweku, briefly, and then, after having gone round, let's hear you briefly.
Lack of trust. That's all, because of the history. Look, there was a time, once upon a time, this country said end of service benefits were wiped away, just like that. When we were privatizing state-owned enterprises and then also consolidating worker salaries for tax purposes, ESB just got lost. And up to today, there are some workers who never got it.
Yes.
They don't trust government.
But the MPs get it in by way of the
Well, there's an
gratia.
extension between end of service benefits.
It's all
and
money. It's all money. Lump sum, huge money that they get.
Well, I get your drift.
You need only 4 years in Parliament and you get it.
I get your drift.
That worker will do 20 years, 30, and you won't get half of what you get.
And I appreciate where you came from, but otherwise there's still an extension between the end of service benefit and as gracious as it were. But money, bottom line is money coming from state coffers.
Okay.
But that is the basis.
So you say the way to resolve this is back to negotiation?
I think so. I think so.
And you say the suit is a wrong move?
It's an escalation that is unnecessary and was avoidable. I can see where government is coming from.
Without the suit, would there be a permanent determination of the issue?
If this thing is not written in Chinese, okay? If they were to sit down,
to the Chinese.
yeah, I'm sorry, they could really resolve this thing. If if the scheme is working and proving beneficial, I'm telling you, there'll hardly be any noise. People just don't trust. There's lack of trust in all this because of the history that we've had. I'm saying we can restore it by showing goodwill in negotiations and get this thing resolved.
Okay, Charles, you don't think the suit is proactive in getting a long-term determination, a determination that says this is what it is and that's what it ought to be, so that in future nobody comes to say this is what the interpretation should be or this is what it should be?
Well, I would want to agree with my senior colleague, Abdul Malik. You see, we know what litigation can do. We know how long litigation prolongs in this country. Now, these people are on strike. Is it a situation then that for as long as this matter is pending in court, they remain on strike, given the possibility of appeals even up to the highest level of the judicial structure? I believe that negotiation was
But
the
you
way
know there
forward.
can be interlocutory processes within a day.
Exactly,
to
but all those
get-
interlocutory processes will can be subject to appeal.
Look,
Exactly.
productivity
You
will
see,
suffer
let me say-
even if the workers are on the job. They can decide not to work effectively.
You see, let me
build a
add that.
Now-
You see, the subject matter is an issue of mutual interest. The government, which is contributing the largest sum of the money, is interested in the outcome of it to ensure that the one for whom it was contributed eventually gets it.
Okay, Dr.
They
Dr.
wanted
Kwesa
to-
has said so.
Yes.
Let me go to the phone lines quickly and let me speak to Mr. Ernest Thompson, who is Director General of the SNITS. Good morning. Thank you very much for joining us on Newsfile, sir. Hello, Mr. Ernest Thompson. Right.
Good morning to your... Hello, can you hear me?
Yes, I can hear you, sir.
Hello?
I can hear you. Go ahead.
Yeah, good morning, and good morning to all your panelists.
Okay, you have either a radio by you or a television set by you. Reduce the volume or completely just mute it.
Is it okay?
All right, go on, so that you can hear me directly. Go on.
Hello?
Yes, go on.
Yeah, can I go on?
Yes, please.
Yeah, I've been listening to the discussion, right, and as the Director General of SNIT, and also as somebody who took part in all the processes leading to the passing of the law, in all the meetings which we had with the Pension Implementation Committee and Parliament and the rest. I just want to chip in some one or two things. One is that the problem we have at hand, the way out would be for the parties to sit down and negotiate and come up with a form of a roadmap. I'm saying so because the law as it exists now, if you recount, started from a process when Joe FM, Kobnadumo, started some publications about SNIT, leading to the Pension Commission being formed and the rest. And the law, if you check carefully, was passed in December, just a few months to the election. It seemed to us that from the problems arising from the law, right, the law was rushed. The issue which has come up is only the tip of the iceberg.
That's correct.
Currently, we've given to the NPRA and Attorney General a lot of amendments which ought to be done to the law. So we need to have patience and have these issues resolved. I don't want to go to the details.
Well, the workers are asking, it's taking how many years? Did you just wake up to realize that these problems are there and ought to be resolved? You've not been proactive enough.
No. Let's take our time. Let's take our time.
No, take your time. How long? Because 2015, they are supposed to begin to see retirees are supposed to enjoy this particular package.
Let me tell you something, that is not a problem at all, because it's a defined contribution scheme. Right. It's not a defined contribution to be spent as interest, as administrative.
Right.
Information is there.
Are they asking for too much? Are they asking for too much when they say they want to see, when they say they want to see statements of the account, what has transpired so far? They have nothing at all to show except assurances, you know, that the money is sitting down.
That's why I'm saying that if you have a little bit of patience, I will explain to you why things have gone that way also.
Okay, go ahead.
You remember that when the law was passed, the capacity of NPRA was itself an issue. You also remember that the former NPRA board had a lot of issues to deal with. Right. But beyond that, let me also make one point. The model we are following, as Dr. White pointed out, is not an homegrown model. It's a World-Bank model, what is called the 4-tier system. We are doing the 3-tier now. The fourth one is the lead on the left. And in countries which implemented it, this is not the way to implement it. We rushed the law. I mean, the custodians were not registered, the trustees were not registered, and the rest. But because of
is that not why the law provided? No, wait, just hold on, Mr. Thompson. Is that not why the law provided for a grace period within which things were supposed to be done, and an implementation committee was also supposed to be working?
I mean, that grace period, it came out because he kept on saying all meetings that if the infrastructure to implement the law was a problem. I mean, I think that if people will be very candid, how come the Bank of Ghana, basically, how come that amendment went through? Was Bank of Ghana ready to receive the money? Currently, do you know what is the public sector money? 5%. That is from Accountant General, goes straight to Bank of Ghana. But the private sector has to pass through me. When initially, the whole idea was that we should not have anything to do with the 5%. But the capacity is not there. So Smith has to receive the 5% of the private and pass it on to the NPR. So there are implementation problems. And also bear in mind that we are running 2 laws now. We are running the 247 and the 750. And there are even issues of people who are paid into wrong schemes. Currently, PwC, Pricewaterhouse, is working with Accountant General. And we are also assisting to resolve some of these issues.
Okay.
That's why I'm saying that the strike may not and will not solve the problem.
Okay.
Let's do this thing well, because it is an income replacement scheme.
Yeah, what workers also want to see is that you appear to be working at a speed, not wait until they, take up, lay down their tools, and then you say, go back, we'll sit down and work.
Let's go back to the structure.
Okay.
Let's go back to the structure.
All right.
The trustees.
Right.
Trustees.
Okay, Mr. Ernest Thompson, thank you very much. He's a Director General of SNIT, and thank you very much for getting through to us. Well, some of the workers' unions have been calling in, and they want to correct one thing or the other. We'll try and put one of them on, but in the meantime, these are some of your comments. Simon in Walewale says, Honorable Haruna must stop using grammar to confuse labor and stick to the issues. This protracted strike embarked upon by labor is simply self-inflicted. The government seems to prefer reactive measures to preventive ones. Bonti Benjamin in Achimebuakwa says the Mahama-led NDC government should be proactive and stop being reactive to the well-being of workers. Sofo Yamusa in Kumbungu says, as a worker, I'm fully in support of the strike action. My pension is my future. It is government's responsibility to come clear on the whereabouts of the two-tier pension scheme. Using propaganda to address this all-important issue will only worsen the situation. I therefore hope that this strike will continue unabated until the lasting solution is found. Musa Abatawa in Kumasi says, I entirely support the Attorney General's intention to seek legal interpretation regarding the Tier 2 issue. It appears the striking workers are up to something or are being politically motivated. If not, they must consider what Haruna Idrisu just said and go back to work. Spike in Ohio, USA says something. I totally agree with the strike by labor unions. I think it is reprehensible, to say the least, for anybody to toy with pension scheme. I urge the leaders of these groups not to relent until their demands are fully met. Atai Moro in Wellensi says, these tactics by government in resolving labor concerns do not help. We saw the same posturing in the case of the Potax strike, only for government to turn around and yield to the demands of Potax. If this strike should continue, it is government that will lose. The earlier our concerns are addressed through dialogue, the better it will be for Mother Ghana. Fredua Ajiman in German South says, district says, it is not strange that workers do not trust government to appoint their managers of their pension funds, because government itself confesses lack of credibility and needs the IMF to restore its credibility. Is this not an admission of failure to effectively manage and supervise the nation's resources in financial management? Trust is key in all of that. Thank you very much. I'll take a break here and we'll return to continue. Okay, now I want us to see how we wrap up on this very subject briefly. And I come to you, Nana. Nana, if you can take just 2 minutes and tell us what you feel is the way forward. Because, look, the hospitals are being abandoned. People are going there for care. They are not getting it. We are told in Tamale it was terrible. Classrooms are empty.
You know, after the declaration of the strike action, it looks like the Ministry of Employment and Labor Relations have been very proactive in calling for meetings. I understand one meeting was called so early in the morning that the workers could not go. Now, with that kind of proactivity being shown, maybe the workers should consider, having shown the government that they have balls and they will demonstrate their balls in this matter, they should go back now that there seems to be some urgency in calling them to a meeting.
Thank you.
But you see, there are still statements being made on this table. That makes me so uncomfortable. Dr. Christopher White goes ahead to say that the workers don't understand. First, he said the leaders don't have expertise. Now the workers don't understand.
No, he's saying you are misinterpreting him, but you are insisting.
I'm just quoting.
That's what he's saying.
I'm just quoting the clear words that
but he's here, and he says you are misinterpreting him.
When you say workers don't understand, it is demeaning. It shows that you know and some people don't know.
Okay.
And I don't believe that we should be making those
Thank you very much.
My last
point.
This business about Mr. Thompson saying that there's some defect in the law was rushed. I don't know how the government is going to court 6 years later on the law that is so the issue is the government and the workers should compromise.
Right.
Find a way of making sure everybody's interest is represented in the management of the funds.
Thank you very much.
That is all that is needed.
Thank you very much.
Has been lazy.
Thank you very much,
for 5 years.
Nana, thank you very much. The statement that the government issued earlier, the first part that they spoke about was that government has accepted to review the National Pension Act to deal with past credit and age. So those issues like Ernest Thompson spoke about are being taken care of. Is that not? Yes?
Yes. For strike action.
Let's say you declared. Mr. Charles Bauer.
The future, I think that we need to look at the object of the law. The preamble statement of the law is very clear. First, to reform the existing system. The system that existed before the promulgation of the law was such that the workers got peanuts upon retirement. So this law came about to improve upon the quantum. And then secondly, to ensure that the money is actually available whenever a worker is going, and to streamline the rules. This issue as to who appoints trustees is a minute aspect of the whole matter.
A minute aspect
very
is what has led us where we are. You call
exactly.
it minute?
It's very minute. It is very simple. Government is not claiming the money. It is all about who should appoint trustees. This is an issue that I think both parties can come together, negotiate, and reach an agreement so as to
they have been negotiating for 3 or so years now. So, yes,
well,
Dr. Kwesa.
Well, first of all, I will say that I don't think that Nana Kumia is being fair by trying to politicize my comments. I think we need to be very frank and honest in our discussions of this nature. Ghanaians deserve better than trying to be partisan on matters of this nature. Pension is a very serious issue, and we should take it serious as such. I think there is also an option. There is an option for Ghanaian workers as far as even the 3-tier pension is concerned. Tier 3 also opens an opportunity for them. Tier 3 is not mandatory. In fact, it is optional. They should be able to, the unions should be able to make a stronger case to their members that yes, Tier 3 is optional, but we also want to make sure that besides getting some retirement income from Tier 1 and Tier 2, we as unions want to persuade you to make some contribution into Tier 3 so that when you retire, you get an additional money in that. I mean, you get some more benefits in addition to where you are getting from Tier 1 and Tier 2. The fixated focus on Tier 2 is probably derailing the whole discussions on pensions in this country.
But don't they have a case when government is telling them that in that account, there is sitting in that account some 447 million Ghana cedis, when they know that the amount ought to be 1.6 billion?
Well, I think that there have been contradictory statements made here, and I think it is proper for organized labor to probably make a contact to Bank of Ghana and get clarity on that particular
2 minutes,
statement.
you are done. Thank you. Abdul Malik, way forward. You've spoken briefly to that already anyway.
Yeah, but you see, was Act 766 indeed rushed?
It was.
How?
The process began in 2004, right?
Yeah. A lot of things went into the process. The TA Bediako thing. For almost 4 years, did the historical interrogation of the pension scheme that we had, some of which Dr. Pesa White alluded to. Okay? And Act 766 ended up repealing the PNDC law, 247, then the long-term loan servicing act, you know. A lot of work went in there. Date of assent was 4th December 2008. Date of Gazette notification was 12 December. But it had, and I think, if you go, I didn't bring the Hansard, but if you go through the Hansard, you see there was also debate and deliberation on all those things. This was something that had been envisaged 4 years earlier, but it needed the expert work before parliamentarians could even sit on it. Now, bottom line, 2011, when government, when, as it's stated here, can I read this thing? This is occupational and personal pension schemes, general. Regulations 2011, LI 1990. In exercise of the powers conferred on the minister responsible for pensions by Section 207 of the National Pensions Act, Act 766, and on the recommendations of the Board of the National Pensions Regulatory Authority, these regulations are made this 16th day of February 2011. Where were they? These regulations were made February 2011. All that time, they hadn't seen that the law, the basic law, the originating law, and the enabling legislation, Act 766, was defective. It's now that there's crisis confronting us that we are saying such things. Look, bottom line, where is the money? Scanaway was our Bank of Ghana. How much is the money? Transparency and accountability. Settle this matter. Now we know where the money is. I'm giving government the benefit of the doubt. That is at the Bank of Ghana. It hasn't been used. What kind of investments have gone on? What is the returns? Put this information out there.
Okay.
Meet the workers. Give them the information. Documented. Records. I read something Imani Ghana put out, and I was quite enthused. I loved some portions of it. Indeed, I loved the whole thing, but I love portions.
You had 2 minutes to wrap up.
Yes, just 2 things. I'll take him 2 because I don't have enough time.
Okay.
He says the NPRA should immediately, without delay, be asked to produce an investment report showing how much monies have been received, it has been invested in, and the returns on the investment over the period. The board chairman or the entire board of the NPRA made to step aside while a forensic audit is undertaken on the stewardship of the NPRA over the temporary pension fund and the investment activities of the NPRA with respect to the same. I support this and more. I rest my case.
Abdul Malik, thank you very much. I still have loads of your messages that are coming in. I'm going to try to see if I can just read a couple more, and then we'll move on to the next issue that we are discussing. Now, I read Spike's message. Let me move on to see if I can read 1 or 2 more. There is... okay. Okay, I'll continue and then as and when. I just wanted to... Okay, there's Alex Akufu Atopa. He says that, how can the government sue workers seeking to compel them to return to work and, on other hand, persuading them to call off the strike? I think the government should choose either of the options rather than going by all the 2 positions. Mumuni, believer... Okay, I don't get the rest of what you want to say, but this one says, if Honorable Haruna Idrisu and government want the security of these pension funds and labor organizations are refuting this analogy, then, okay, let's have the necessary documentations released to the unions. And then health sector workers unions such as the GMA, etc., should stop using precious lives as bargaining tools. Ghana deserves better, and they should remember the oath they swore. Thank you for those messages. And when you are sending them, do try and read over so that you can edit it as well. It's important. Now, before we started, as I mentioned to you, the law is simply that these deductions are made, and when the deductions are made, they are supposed to be held in trust by the employer. They are supposed to be held by the employer in trust until they have been remitted to the trustees. And this is supposed to be done within 14 days. Within 14 days from the end of each month, this should be remitted to the trustees. And then after that, there is supposed to be the transfer of these funds as well by the trustees to the managers that have been chosen as well. So all the questions that are being asked in respect of all of these, let's see how the assistance will come in as by way of government's intervention in this matter.